Hello, my name is Aine Flynn and I'm Director of the Decision Support Service. In this presentation, I will talk about what the new Assisted Decision-Making Capacity Act of 2015 could mean for you. I will talk about what the Act says about your right to make your own decisions. I will also talk about the different supports that will be available if you need them. And I will tell you about the Decision Support Service and what we do. We're talking here about the Assisted Decision-Making Capacity Act, which has finally now started working. It began to work as law on the 26th of April 2023. The Assisted Decision-Making Capacity Act supports the rights of people to make their own decisions, and I'm just going to call it the 2015 Act. The 2015 Act helps us to do what it says in the United Nations Convention on the Rights of Persons with Disabilities. Let's think about some of the things that the Act does. It replaces the wards of court system. It contains important guiding principles. It puts in place new levels of what we call decision supports to help people with making decisions now or in the future. And it sets up the Decision Support Service, and I'm Director of the Decision Support Service, and we call that the DSS sometimes. And there are codes of practice for people to follow. Why did the law need to be changed? There was an old law called the Lunacy Regulation Act of 1871, and under that old law a person can be made a ward of court. When somebody is made a ward of court, the President of the High Court makes decisions for them. The new law replaces the old wards of court system for adults, and adults in this Act means people over the age of 18. All adult wards will be coming out of wardship within 3 years. And the court will decide whether they need supports after that under the new Act. There will be no new adult wards of court. If anybody needs to know more about that process for coming out of wardship, that is all being looked after by the Office of Wards of Court, and the DSS can point you in the right direction if you require information about that. What does decision-making capacity mean? Decision-making capacity is about being able to decide about a particular thing at the time that you need to decide it. The Act talks about the functional assessment of capacity. And this is the way that capacity is assessed if somebody's capacity needs to be assessed. And this means being able to understand the information about the decision that you need to take, being able to remember that information for long enough to make your choice, using or weighing up that information in order to make a decision, and then communicating your decision in whatever way you communicate. People can have all sorts of ways of communicating. Some people need sign language, some people use technology, sometimes people just rely on the person who knows them best and the way that they communicate. If you have particular communication needs, then these communication needs should be met. And the fact that you have communication needs doesn't mean anything about your capacity. The Act contains important guiding principles, and these are rules which people have to follow. The people who have to follow them are the decision supporters, and I'll come to them in a minute, and other people have to follow the guiding principles also. And here are some of the guiding principles. So, to begin with, it is presumed that every adult is able to make a particular decision. A person has to be given all the help that they need so that they can make their own decisions. A person's will and preferences should be respected. And if a person wants to make a decision that seems unwise, that doesn't mean that they are unable to make that decision. We have to respect a person's right to decide what happens to them, to their body and to their property, and we have to act in good faith and for the person's benefit. What sort of decisions can be supported under the 2015 Act? There are property and affairs decisions, and there are personal welfare decisions. Under property and affairs, we could have decisions, for example, about needing to buy or sell or rent a house. Decisions about how you spend your money and pay your bills and taxes. Decisions about providing for other people, applying for benefits, carrying on a business or winding up a business. Decisions about legal matters like going to court. The other sorts of decisions then are personal welfare decisions, and these could be decisions about accommodation, deciding where you're going to live and who will take care of you. Decisions about healthcare, for example, deciding if you should have medical treatment or dental treatment. Deciding about education or training courses, planning holidays and social activities. Taking part in research, there could be decisions about that. And using social services such as attending a day service and anything that relates to your welfare. There are some decisions which are not included under the Act. And these include decisions about making a will, decisions about getting married, getting divorced or separating, decisions about placing a child for adoption, consent to sexual relationships, being a member of a jury, decisions about the guardianship of a child. What the Act is saying here is that any of the new decision supporters cannot be involved in these sorts of decisions. And who do we mean by decision supporters? The Act puts in place new types of support. This doesn't mean that everyone is going to suddenly need one of these new arrangements. That is always going to depend on each person and the sorts of decisions that they need to take. There are 3 different types of new decision supports, depending on how much help a person needs to make particular decisions. A person is also able to plan ahead for a time in the future when they may not be able to make their own decisions for themselves. And we call all of these people decision supporters. The first one we're looking at now is the decision-making assistant. A person can choose to have a decision-making assistant to help them. This is somebody that they already know and trust. And the decision-making assistant helps the person to get information and helps by explaining it to the person and helping the person to communicate what they want to do. The person is still making their own decisions. At the next level up is the co-decision maker. So if a person wants to make certain decisions jointly with another person, they can choose somebody that they already know and trust to be their co-decision maker. And together they make an agreement called a co-decision making agreement. And they send this agreement to the DSS. Afterwards, the person and their co-decision maker make these decisions together. If they have to sign forms, they're signing forms together. The DSS checks to make sure that this arrangement is working well. And at the next level up, we see the decision-making representative. So if a person can't make a decision, even with supports, if everything has been tried, then an application can be made to the court. You're asking the court then to decide whether the person is able to decide about the particular thing or things. The court can make a decision-making representation order, appointing a decision-making representative. The court order decides who the person's decision-making representative is going to be. The court has to listen to who the person wants to be their decision-making representative. And the court then will say the types of decisions that a decision-making representative is allowed to make. And what can they do? A decision-making representative can only make the decisions that the court has set out in the decision-making representation order. They can't suddenly try to make all of your decisions for you. And the decision-making representative still has to talk to the person and find out what they want to do. And this is, remember, about respecting will and preferences. The DSS checks in to make sure that this arrangement continues to work well. If somebody is making an application to court about your capacity, then you can get help from the Legal Aid Board. The Legal Aid Board will also help people who are leaving wardship, and more information is available from the Legal Aid Board, and we can point you there if need be. Thinking then about planning ahead and the enduring power of attorney, it's a good idea to plan ahead. Any adult can choose someone they trust to make decisions for them at a future time if that becomes necessary. And these can be decisions about property and affairs or personal welfare or both. And all of this is planned for in a legal document called an enduring power of attorney. When you make an enduring power of attorney under the new Act, the DSS will keep it with their records. So when you make it, you send it to us and it goes on to our register. But it only starts to work if you become unable to make the decisions that are included in the document. And then the attorney starts doing their job and making decisions for you. The other way of planning ahead is the Advanced Healthcare Directive. So this is all about medical treatment. In an Advanced Healthcare Directive, a person can set out their wishes about their future medical treatment. Like the enduring power of attorney, The Advanced Healthcare Directive only starts to work if the person becomes unable to make these decisions by themselves. And they can choose a person to make medical treatment decisions for them in the future. The person they choose is somebody that they trust, called their designated healthcare representative. The designated healthcare representative's job is to make sure that people know about the person's Advanced Healthcare Directive and respect the person's wishes when it comes to treatment. How does the Decision Support Service make sure that decision supporters are doing their job? We supervise decision supporters to make sure that they are acting as they should. 3 of them, the co-decision maker, the decision-making representative and the attorney, have to send us reports. We will help them in this if they are finding it difficult. If they do not send in the reports, or if they don't send in the reports properly, we can follow up with them. The DSS will have help from our team of general visitors and special visitors. We can ask them to visit the relevant person and other people to make sure that everything is being done properly. The general visitor or special visitor will send us a report along with any documents that we may need. And if the decision supporter is not doing their job properly, they might be removed from their role. We keep a register of decision support arrangements. That's a list of the co-decision-making agreements and enduring powers of attorney and the decision-making representation orders that come to us from the court. People or organisations can look at this register of arrangements if they need to, and we will keep a record of any person or organisation who's been allowed to look at the information on the register. And you can see how that might be important. It could be that somebody in the bank or somebody in the hospital wants to be sure that your co-decision maker, for example, really is who they say they are and that they are allowed to decide with you the things that they are looking to decide. We can take complaints, and this could happen if a person is unhappy with the way a decision supporter is acting or how a decision support arrangement has been set up. They can then make a complaint to us, and we will investigate and try to get things working again if that is possible. We might have to send the matter to court, and the court can remove the decision supporter from their role. We hope that for the most part we will be able to solve complaints without having to do this. And our codes of practice. These are sets of guidelines to tell people how to use the Act, and you will find all 13 of our codes on our website. There is a code for everyone about supporting people to make their own decisions and the right way to assess capacity. And there are also codes of practice for decision supporters, healthcare staff, lawyers, advocates and financial services. And this means that these people should all know how to follow the Act. And you will also find on our website a document called Your Guide to the Codes, which tell you what the different codes could mean for you. Thank you for viewing this presentation. On our website you will find more information and guidance, including other videos and an easy read version of the Assisted Decision Making Capacity Act. You are also welcome to call our Information Services team on 01 211 9750 or email us with any query you may have at queries@decisionsupportservice.ie.